Ladies and gentlemen, good evening and welcome to this evening's Ramsay Center lecture. My name is Martin Fahey. I'm the CEO of the Ramsay Center for Western Civilization. The lectures and events like this are not possible, and our program of events and scholarships, both at undergraduate and postgraduate level, are not possible without the amazing generosity of our benefactor, Paul Ramsay AO. As a philanthropist, he's left an incredible legacy, a life well lived, a life of contentment, but a life of amazing generosity lived for others. And his legacy through the work of the Paul Ramsay Foundation and indeed through the Ramsay Center for Western Civilization, I think will pay homage to that life. I'd also like at this point in time to note apologies from our chair, the Honourable John Howard. He's got a previous commitment, unfortunately, that he has to meet. And so he apologizes for not being here, but I think he would endorse the topic that we have tonight in terms of the rule of law and well-tempered power. This evening, the format for this evening, after a brief introduction to our main speaker, Martin Krygier, Martin will speak for about 40 minutes, and then we will have a response from Michael Sexton, and then we will have a Q&A with both of the speakers. We promise to have you all back out with a drink in hand and something light to eat by about 7:30, with the conclusion at 8. I'd like to begin by introducing our main speaker this evening, somebody who's been incredibly generous with his time as a public intellectual, as an academic, as a supervisor, and as somebody who has left a mark on the debate on power, arbitrary power, the rule of law, and in the case of tonight's lecture, a discussion on well-tempered power. Martin Krygier is the Gordon Samuels Professor of Law and Social Theory at the Faculty of Law and Justice at University for New South Wales. He's held positions at numerous universities around the world, including the Central European University Democracy Institute in Budapest. He's a fellow of the Academy of the Social Sciences in Australia, and he's published widely on the topic of the rule of law. His genealogy is marked by the tragedy of intolerance, totalitarianism, and authoritarian regimes. And despite all of that, he's managed to, I think, embrace the civility and tolerance and kindness that we look for in our public figures. Martin's going to talk tonight at length about well-tempered power, how to think and not to think about the rule of law. In some respects, the rule of law could appear to be in crisis, not just within our broader society, but within the academy in terms of how it's perceived. As a protean term, it carries many meanings and freights many concepts. But ultimately, it is one of the foundational ideas in our political vocabulary, in our political institutions, and our social lives. Martin will begin by outlining some of the challenges of could we be in a better place? What are the questions that we need to ask about the rule of law? And importantly, the sequence in which we need to address those questions. So, ladies and gentlemen, it's my great pleasure to invite to the podium Professor Martin Krygier.
Thank you very much, Martin. Thanks for those generous words. I hope that nobody will be rude enough in the Q&A to test their plausibility. And thank you all for coming. I was told that it was a full house, and I thought, well, it must be a small house, but there are a lot of people here, and I'm grateful that you are here. Because the subject is truly important. I will have a rather, I think, eccentric take on it compared to most, but whatever take one has, we're talking about important things. The rule of law has, in the last 3 decades or so, been the subject of more words, more spending, more attempts to promote it than at any time in human history combined. I haven't done the maths actually, but I'm prepared to bet on it. There is a reason why I say 3 decades, and if anybody wants to ask that reason, why this extraordinary effusion of interest in the rule of law took place worldwide since the 1990s, I'm happy to go into it. It's a fascinating subject, but it's not my subject for my particular remarks today. But notwithstanding all of that attention, all of those words, all of that thought, all of that money, billions of dollars have been spent on rule of law promotion programs by international agencies throughout the world. We don't have a very happy story. At the theoretical level, one English constitutional theorist, Martin Laughlin, recently said in a nice phrase, the rule of law is a slogan looking for a concept. And another political theorist whose book was just in a few weeks ago, the book is called Law's Rule. It's a tribute to the rule of law, a very fine book. He said, very often we simply don't know what we're talking about. And having read many of these books on the rule of law, I can say yes to that. And that's at the level of theory. In practice, the situation is no better. One rule of law, when I talk about practice, I mean attempts to generate the rule of law. The usual term is build, as though it was something that could be built. In that field, one promoter confessed somewhat ruefully some years ago, we know how to do a lot of things, but basically we don't know what we're doing. And that's been borne out in one rule of law program after another, done by very clever people, trying very hard, well-funded, but yet without easy successes. Not no successes, but easy successes. There are various rule of law indexes which have sprung up in these last 30 years where people try to measure the rule of law. The UN has a rule of law index. The EU has a rule of law checklist. The most comprehensive and sophisticated of these indexes is the World Justice Project's index. It's not uncontroversial that what these people are measuring, and they measure different things, each index has a different thing. Freedom House has a different set of criteria than the UN or the World Justice Project. But whatever they're measuring, they all agree on one thing. Rule of law is going down worldwide. The last report of the World Justice Project came out at the end of last year, says or has measured that on its metrics, in the last 6 years, the countries where rule of law has decreased overwhelm the countries in which rule of law has increased 6 consecutive years. They estimate that 6 billion people, that's 76% of the world's population, are living in a country where the rule of law scores as they make them decrease. And yet, I mean, that's a sad story, but if it didn't matter, who would care? But it's a sad story because it does matter. And what I'm going to suggest is that there are many, it's not easy to build the rule of law where it's in trouble, but I'm going to suggest that's not the only problem. One of the problems, and the one on which I concentrate, is how we think about the rule of law. And I think we think particularly poorly about the rule of law. In a moment, I'm going to sketch what I take to be some of the characteristics of conventional ways of thinking about the rule of law and suggest an alternative. And I should warn you, I'm about to unleash a torrent of words, and if you feel that you're drowning or I'm drowning, just hang on to a piece of advice which came from an unusual source, but a very profound one. I'm told, one Noel Archibald, who was, I'm also told, once CEO of Black & Decker Power Tool Company. And he advised his staff that no one goes to a hardware store to buy our drills. They go there because they want to make a hole in the wall. That's a deep remark, and really everything that I say, if you don't know what I'm saying and it just, remember that is the theme of the next. And as Martin mentioned, I take issue on quite a lot of things with conventional accounts of the rule of law. In particular, I think they start in the wrong place, they go on in the wrong way, they end in the wrong destination, which is not a great way to start a journey or finish a journey. And I think where you start really matters, because if you start in the wrong way, and I take conventional approaches to start in the wrong way, your discussion threatens always to be pointless, literally pointless, without a point. And the order in which you then go on also matters, because some questions it only makes sense to ask when other questions have been answered. You probably all remember, not that we were there, but, well, you must remember it anyway. So let's go on. All right, where to start? Well, let me just sketch conventional. Of course, I've said that the rule of law, the concept, is hugely controversial. Nobody seems to agree with anybody else, but they all do agree, the conventional approaches, on where what they're talking about is. So, and that is, the rule of law is a virtue of the official legal system to be found by some characteristics or other of the central institutions, legal institutions of the state. Then there are endless disagreements. What features really count? But that's where you look is common. So the term was not invented by him, but it had its contemporary career, or its career over the last 150 years, because the Vinerian professor of law at Oxford, Albert Van Dicey, gave what was terrific for law students, 3-point definition. The rule of law happens, and it only happens in England, I'm sorry, go across the channel, out of there. It only happens in England because only England has this tripartite collection. One, that power holders can't act arbitrarily or even with discretion. Secondly, that everyone is equally subject to what he called the ordinary courts. Of course, because he's a common lawyer, he emphasized courts, whereas the Europeans don't. But he says ordinary courts. So because France had special courts for administrative stuff, they're out the window. They don't have it. And go further east and it's worse, of course. And thirdly, the English constitution, its uniqueness, its specificity was that it welled up from below, from court judgments, rather than descending from the interpretation of some particular document. Now, generations of English lawyers learnt this parochial account, and it then became exported even as far as here. With occupants of the building next door, about whom, if there's time, I might say a word later. Now, legal philosophers don't concentrate as much on specific institutions because their imagined audience is everyone in the world. It's not just Australians or the English. They focus typically, particularly in the last 60 years of discussion about the rule of law, on the character of legal rules. And they say, look, you've got the rule of a very famous and wonderful man from Harvard, Lon Fuller, started the game going, but he's been repeated by so many other people, and it's become, I don't think you can get into Oxford without knowing this story. So for the Fuller and then Joseph Raz, an Oxford philosopher, for these people, you have the rule of law when your rules have certain form. They're not retrospective. You've got to know them when you're making a decision. Citizens have to know them. They're clear. They're not ambiguous, in other words. They're not contradictory. The whole list, and there are 8 usually, but some have 10, some have 15, some have 20, but they're all doing the same thing. They have these laundry lists of features of legal rules, and they say that is the rule of law. And then a very brilliant New Zealander who was then at Oxford learnt this stuff and then went to New York, and he had the courage to say, no, it's not that. It's not just that. It's not just formal aspects of rules. It's procedures. You need to have procedures which allow people to have a voice, to make a difference. And he focused on procedures in the criminal courts. I don't know how many of you have been in the criminal court. I never have. But it's an index, I think, of part of the kind of narrowing focus of general discussions of the rule of law, that they focus not only centrally, but as though this is where you're going to find the rule of law. And then when you have rule of law promoters going out to countries, as I've gone to Myanmar with the sort of success you can read about in the papers, then they too have a whole range of institutional suggestions, court practices, court buildings, how to train judges, and so on and so forth. Now, the details don't matter to me because I don't want to dispute any of them, because I think they're all playing the wrong game. And I think they're playing the wrong game for, at the moment I have 7 reasons. 5 of them are pretty well, I think, general. They happen wherever, the mistakes happen wherever they're tried. 2 of them are of more recent and contemporary distinctive significance. But let me start quickly with the first 5? Well, first of all, problems change. People who value Western civilization or value Aristotle, if they don't value Aristotle, they value Plato, but probably they value them both. And Aristotle said the rule of law is better than the rule of any individual. So he's on side, but the problems he was facing, as you can imagine, were not quite the same as we in the world of AI and Facebook and Viktor Orban and other people. So the problems differ. Of course they differ. But then circumstances differ. You might have the same problem as an unwieldy, wild dictator or proto-dictator wants to throw his weight around, but if he's doing it in India, how you're going to deal with that likely is going to have to take account of India as distinct from Turkey. So circumstances differ. So if suddenly it's going to work somewhere, it's got to be, if you're grafting, instead of building, think of cultivating. If you're going to graft the rule of law, you're going to have to do it differently in different places. And then responses, institutional responses differ, must differ. We think differently, we have more options open to us, we learn. And sometimes we forget. Fourthly, we have typically, and I fear that there may be some lawyers in the room, because I think, like every member of a real profession, there are professional deformations. Man with a hammer, to a man with a hammer, everything is a nail. To a lawyer, everything is a problem that, if it's particularly the rule of law, something which is something that they know a great deal about. But when we're talking about the rule of law as something of significance, it's not just a legal significance. We want it to be of significance in the world. We want somebody in Myanmar not to be pushed around, before he's pushed around by the generals, not to be pushed around by some local notable without any recourse. We want little mafiosi not to be able to do what they want with us wherever they want. We want Al-Qaeda to be under control. We've got all these things. So what we want is something which effectively handles social causality, which is a complex thing. That is, what you do here, you've got to be able to predict it's going to have this effect here. But lawyers commonly, none of the people in the front row, but other people commonly think that, or they don't have a worked through version of what happens after the law is passed. And social causality is a very complicated thing. And so fifthly, it's not a surprise that rule of law promotion is not a success story. In fact, it's a very sad story. Great intentions, many of things, particularly in Central Europe, which is most concerned me. I was so optimistic, so excited in Poland, Hungary in 1989, and my excitement has dimmed somewhat in recent years, and I'm not alone in that, of course. But let me come to sixth, because this is more distinctive. It's not just that these various virtues of law, clarity, non-retrospectivity, particular institutions, particular ways of doing things, constitutional courts. After the collapse of communism, only 2 countries under communism had constitutional courts, and they were facades. After the collapse of communism, every country got a constitutional court. They got constitutions written on the best models, and many of them have gone to seed. So it wasn't a technical problem. And for the first 20, 30 years, I was actually very optimistic about what was happening, but I started to think, a lot of the action is not happening in the law. We put all this stuff in, but nobody cares. There is a deep Bulgarian saying. I was on a bus in Sofia in Bulgaria, and the guy next to me was a young athlete, and so he asked me what I did, and I said, well, I'm a bit involved with law. I said sheepishly, he said, you know what we call the law in Bulgaria? The law is like a door in the middle of an open field. Of course, you could go through the door, but only an idiot would bother. And there are many countries where, for a whole range of reasons, because you're scared of going through the door, because nothing good will happen to you going through the door, because nothing useful will come from going through the door, many countries in the world where that's not only the general impression, but it's also the truth. So that was my worry, that the law didn't count. But over recent years, it has been discovered and I've observed, that not only do many of the rule of law nostrums we're familiar with fail to deliver the goods, but often they are complicit in delivering the opposite of the goods. Give you some examples. In 1933, when the Nazis came to power in Germany, there were two German Jewish lawyers, one of whom fled. Franz Neumann, very famous figure in the West, wrote about Nazi Germany. He said there's no state there, there's no law there. His partner, they worked for a union, his partner stayed because he'd had a good war record in First World War. His name was Ernst Frenkel, and he was allowed to stay, even though a Jew, until 1938. And he devoted those 5 years not simply to his practice, but to documenting, like an anthropologist or an ethnographer, how the system worked. And unlike Neumann, he said there is a state and there is law, and in fact there's more than that. There are two states, and there are two sorts of law. There is what he calls the prerogative state, where the ruler can do, or the ruling party can do what they like. But there is also a normative state. An Aryan wants to marry, wants to start a business, wants to form a contract. They have a lot of law in Germany, a long history. They've got stuff to work off, and for most of that time, it worked the way the law worked. The problem was, or should work, the problem was that the prerogative could make political and politically relevant whatever they wanted, whenever they wanted. Now that is a model which has been adapted to analyse contemporary China. A lot has been written now about, by sinologists, about law in China, which says, well, that's what... Even Xi Jinping, who is much more arbitrary than his predecessors since Mao, but even he doesn't want some local notable messing up what he wants the local bureaucracy to do. So he has insisted on a whole swathe of areas where law counts. But that is not the rule of law if the rule of law is got to be associated in any way with the tempering, or in more common terms, tamering of significant power. In China, the most significant power is at the top, and that is untamed. Now, I say contemporary, well, Frankel was not really contemporary, but the reason I'm so interested in this abuse of technical forms is that in the countries I look at, because I do a lot of, in recent years, looking at populism in Central Europe, but also in other places, what distinguishes many of the Central Europe populists, for example, Kaczynski, who ran Poland until the end of last year, Orban, who was running Hungary until he dies and maybe afterwards, is that they do not treat law as something to be got rid of. Lenin said, the dictatorship of the proletariat is ruled without law, unrestricted, ruled by force, unrestricted by any laws. He meant it, he wasn't apologizing, and he was right. That's what it was like. But it's not like that in Hungary, it's not like that in Poland. Here, legal forms, legal institutions, first of all, are flattened, and then they're absorbed. This happened, for example, the Constitutional Tribunal, which was a significant body in Poland, was flattened first. It was rejected, its decrees were not published, its decisions were not published, and once it was flattened enough and enough new judges could be appointed to it, because they're all appointed by the former government, now it was absorbed. So now it simply does the government's bidding. Yet, a lot of the legal forms are kosher. And that is a worry. If the rule of law is thought of as something that should be important, you've got to think, well, if it's important, and if these forms are so malleable to abuse of power, maybe we haven't got at what makes it so important. And finally, seventh, in Poland, one of the interesting things is that the populists lost, and now there's a whole range of people trying to re-establish the rule of law, as they put it, in circumstances where the previous regime has cemented its own institutions, its own people in various places, very hard to move them. So one of the important things is to try to explain to people in the world, in the society, why this matters. If you talk to them purely about legal technicalities, they may well at some point ask, what's the point? If you say Section 6 is a bit vague, or this particular law was badly constructed, or this constitutional court, the procedures for appointing the judges were mangled in some way, but according to law. And now it's simply in the service of the ruler. They might say, yeah, well, tough. So what is the point? And that leads me to say we should start in a different way. The rule of law, however much you love it, is not like the Sistine Chapel. It's not something you think is just wonderful in itself. It's a different sort of thing. People who call for the rule of law think of it as a solution to some sort of problem. That's what it's good about. It's more like a cistern than a Sistine. Sorry, that's a bad pun, but it occurred to me as I was working here. It's like plumbing. You want it to work, and it's fantastic if it works, but you don't love it for its beauty, its shape, it's this or that. It's because it does something good for you. If that's the case, and in this case, like with plumbing, it's part of what it does is stop bad things happening. Well, you know what happens with that. So I want to suggest, to understand, to come at what's important about the rule of law, you should start the other way around, not trying to deliver some list of anatomical features. The rule of law is A, B, C, D, but say, what's the problem that the rule of law is after? Why does it matter? And what would we want to happen? What would our goal be to deal with that problem? So first of all, the problem, and here I'm completely unoriginal. A lot of people have said it. Very often people have said the distinctive issue for the rule of law is arbitrary power. Now that's an important combination. Many people say the rule of law is against power. Friedrich Hayek, the great, now we call neoliberal, but then liberal economist, philosopher, said power is the arch enemy. That's nonsense. You don't secure any rights without power. You don't have safe streets without power. You don't have court systems where judges do what they like. You don't have jurisdiction without power. All of this has to be backed by power. So power itself is not an enemy, but power is, particularly when it's concentrated, is prone to all sorts of pathologies, and people use this general word arbitrary for many of those pathologies. And I think, yes, arbitrary power is horrible. And I should say very briefly what I mean, and again, none of this is original, but very often people say arbitrary power is the problem. And so you've got one concept you don't understand, rule of law, and you say, what's the problem? Arbitrary power. You don't understand that either. But you keep going. So I want to suggest it's not a definition, but 4 sorts of exercise of power which are dangerous because arbitrary. 1 is when power is uncontrolled. 2 is when power is unpredictable. You just don't know where it's going to come from. It's like lightning. 3 is when it's unrespectful. That is, it treats you like as one philosopher has put it, like a rabid dog or a dilapidated house. Sometimes I get it wrong, dilapidated dog, rabid house. But it doesn't treat you like a person. It doesn't give you an opportunity to speak, to give your point of view. And so the procedures that Waldron, who I mentioned earlier, mentions are important. If somebody's taking my house or suing me or claiming I've defamed them, I need my day. Not just in court, though, because a lot of the ways in which power treats you unrespectfully are not the rare events which happen in a legal court. They're what happens to you in the street. What happens to you when somebody has more sway over whatever happens locally. And finally, power on this version is arbitrary when there's no match between uncontrolled, unpredictable, unrespectful, ungrounded. When there's no match between the way power is exercised and any ostensible reason for it. Using a sledgehammer to swat a fly, for example, is. We don't talk about respect for flies, but you've got the image. All right. All of those forms are reprehensible uses of power for reasons that I quickly will divide. One is a fancy term, deontological, consequential, and intellectual. Deontological, in moral philosophy, they distinguish often between things that are wrong because you simply don't have a right to do them. You have a duty not to do them. You should have a duty not to lie. But I needed to lie. Well, some people who are strict deontologists will say, tough. You should never lie. So there are deontological reasons why arbitrary power stinks. Nobody should be in a position where that is done to them. And nobody deserves nobody deserves to be treated like a dog or a dilapidated house. And nobody has a right to treat people that way. There's more to be said on that, but I'll skip over. Then consequences. Clearly, and there's a grand lot of writing about this, particularly also personal testimony writing, how fearful it is to live in a society where power can hit you any way, without any control, without any predictability, in a way that is completely unrespectful to you, or is completely out of any relationship with whatever it is you're alleged to have done. Freedom is restricted, and both fear and unfreedom happen if you have a system where power can be arbitrary, wild, not only when it's actually exerted against you, when you are hit in the face, but the terrible thing about arbitrary power when it's institutionalized or available regularly, routinely, is that you are in fear and you are without freedom whether or not it's being used against you. So if you know in the doll's house where the wife has a husband who loves her, he could do anything to her, but he doesn't because he doesn't, but she's still trapped. Or a slave who is treated well by a slaveholder is still not free because the slaveholder chooses not to exercise their rights against you. So that's why arbitrary power stinks. Well, what to do? Standard responses are negative or defensive. What you do if you are frightened of arbitrary power, if you think that arbitrary power is awful, you should limit power, restrict, curb, constrain. They're all chopping off words, as though it's the power itself that has to be limited to keep people safe. I've already said that power is a hugely constructive thing. We need it. Power is the ability to make changes. We need that. We need protectors too. It may be that we're our own protectors, but we need other protectors as well in many circumstances. So that's not the question. The negative view seems to me systematically underselling what we need from a concern to diminish the sway of arbitrary power in our lives. And I knew the term tempering because I'd read it, but I thought, well, that's what you need. And I was very pleased, and then when I started to read, I was still pleased because I think it's the right term, but a bit less proud because I discovered Cicero had thought the same. And Bracton, the English compiler of laws in the 13th century, also thought the same. They used the same word. And I've tried to explore a little some of the connotations of that word, and they're enormously fertile in English. They don't happen this way in every language. And of course, this is a Latin-based language, which is why it's this word. So I'm not trying to say this is a transportable concept that you could use anywhere. I'm just saying we have this term, and its connotations are hugely fruitful for the following couple of reasons. The Greeks had a term, sophrosine. If there are any Greeks in the room, I already apologize for the pronunciation. But sophrosine was a virtue which some of the great heroes, flawed heroes of Greek tragedies lacked, because they were brave, they were clever, they were etc., but they had hubris. They weren't thoughtful. They weren't reflective. There was no balance in their conformation. They would go wild, and so on and so forth. Cicero took over the term and he translated it as temperantia, and then it became one of the cardinal virtues. It already was for Plato, but then it became in Catholic theology, and it's one of the cardinal virtues. And it talks about balance, measure, thoughtfulness, self-reflectiveness. That's a lot that we want from power. It is. It's a good thing to have. It's a good thing to have at a personal level, obviously. It's also a good thing to build into your institutions of power wielding. You want them to be, and there's a great deal of experiments, separation of powers, which is never just separation. Because if it was separation, it would be the weakening the power. It brings it together. You separate, but then you coordinate. So those virtues move towards what the great French analyst of such matters, Montesquieu, valued as moderation. Everybody else would divide governments by number of people, oligarchy, aristocracy, etc. Montesquieu knew about that stuff, but he said the real difference that matters to him is between moderate and tyrannous governments. And that's the difference that I think matters to anybody who has this frame of concerns in mind. But why tempering? Why is that so attractive? Partly already because of this, but also if you think about tempering steel or tempering glass, you make them stronger by making them more resilient. You're not limiting power. In fact, you're strengthening power. But it's a strengthened power, which you use it with the other connotation, is able to be wielded thoughtfully. It's not just a sword, although a sword should be from tempered metal as well. So I'm not going to tell you anything. I was trying, when I gave the title to Martin, I was still trying to work through whether I could get music into it, because of course I should. But in fact, temperament in music just doesn't go there, as I've now learnt to my cost, having put that term in half a dozen titles. So I'm not talking about tempering in music, I'm not talking about tempering in chocolate, I'm certainly not talking about tempering in alcohol. I'm just saying that these connotations of temperance as a virtue of persons and institutions are important. And once a final source of a final connotation which pleases me. I was once in Poland and I was asked by a journalist what I thought was wrong with Polish institutions, and I said, well, there's a lot to say, but one central thing is there's no idea of tempering power here. But we were talking in Polish, and my Polish is adequate enough, but it's got lots of holes and gaps and mistakes. And he said, so it should be tempered like the point of a quill pen, so it doesn't throw blots around all over the place. I didn't know what he was talking about. I said, yes, exactly. And then I looked up, or in fact, because the thing came out in the newspaper, so I looked it up, and temperówka is a pencil sharpener. And tempering, in this sense, sharpening, certainly is a connotation I wanted. That sharpening, focusing, making, in the way that the philosophers talked about the virtues of clarity, of lack of contradiction, of coherence, I buy that too. But as you see, I'm not a philosopher, so I allow myself to be vague. Anyway, I can't do anything else. So, tempering seems to me a virtue, and that's really my story. This is, but I haven't finished, this is how we should think about the rule of law. It is a device to try to deal with a particular mischief which is very pervasive, that is arbitrary power. And what it seeks to do, what it should seek to do, is temper the exercise of power. But there are some implications, and I'll simply run through them very briefly. One is, if arbitrary power is so horrible and tempering power so awful, then the traditional focus of rule of law discussion, which has been almost always on acts of state, how do you get the government to act in a... That's important, of course, because the state has a disproportionate significance in the worlds we live in, but it shouldn't be the only thing. If you think that I know nothing about AI or Bitcoin or further down the alphabet, Facebook or Google, and even further X, but it seems to me that even with that sample, you've got quite a lot of capacity of exercise of arbitrary power. People concerned with the values, the ideal that generates thought about the rule of law should worry about that. So first of all, I would, and elsewhere I've tried to do it in more length, argue that a lot that we consider private when it has manifest public effects should be captured in our thinking about the importance of tempering power. Secondly, if you think, and now at last, I get to where most people start. Well, if that's what you want, what do you do about it? Rather than saying this is what we do and we hope it'll have these consequences. Okay, if you want this, what should you do about it? But now it's much more complicated. Because why would you think in a world, in societies as complicated as ours, that law can do it all on its own? And no one will say that law can do it all on its own. Well, if law can't do it on its own, why do you focus just on these features of central legal systems. We don't know what this legislation is going to do out there. We don't know how it's going to affect. We don't know the social confirmation, which is very important. In Poland and Hungary, they didn't just go after the courts, though they did. They went after the media. They went after the central bank. They went after the procuracy. They went after. They went after NGOs. So anybody who's got any money from anywhere else, and everybody's got to because you don't have money, becomes, under the recent Hungarian law, a foreign agent. So under the scrutiny of an agency which has extraordinary powers. So to think seriously about the ideal for which one thinks about the rule of law, you have to think sociologically. You have to think about how societies, what is happening in the rest of the society, what supports it. I think that very often in a society where some of these social and I mentioned cultural supports exist, the law can be what you like. I don't mean that actually, but there's a lot of slippage available because the background conditions are supportive. But where you don't have that, whatever the law does is not necessarily going to make very much difference. And it's not only sociology, it's politics too. Very often when first generation rule of law reformers went into countries that they wanted to bring the rule of law to, they would say, look, there's an absent. They don't have the rule of law. In Myanmar, they don't have the rule of law, they would say, when the generals were in power the earlier time. We bring them that now, and we show them how to do it. So it's a problem of knowledge. They didn't have it, they didn't know it, we know it, we'll bring it to them. Then when everything failed, you would say, well, maybe we need to learn a bit. So we'd study up local practices. That's already a point, that's already an advance to try to find out, well, maybe Myanmar is not the same as Oxford. Maybe it's not. Yangon is a little different. That's a plus, but it's not enough of a plus, because the problem is not that the present and then rulers of Myanmar don't know the value of the rule of law, or that Orban in Hungary, who is a lawyer, Kaczynski in Poland, who has a doctorate in law, that they don't know the rule. They know what it's about, they don't want it. They have a different project. Their project is domination, is concentration of power. They have found in recent years that legal instruments, even some of the most sacrosanct among rule of law thinkers, actually, to some extent, with trimming and cheating, more cheating in Poland than in Hungary. In Hungary, because Orban has in 3 elections always got a supermajority, he can just change the constitution when he likes. So he doesn't have to cheat that much, though he cheats anyway. But in Poland, they didn't have a supermajority, so they had to cheat more. But either way, it's not the means which were the issue. It was the disposition, the ambition of the rulers, and that's a harder thing to deal with. And finally, or almost finally, many of these conditions are deeply cultural conditions, and unfortunately I'm happy to talk about it in Q&A, because that can be a very slippery term. But one author talked about the notion of the rule of law, and I've been reading him a lot, and I just wrote a piece about him as a historian called E.P. Thompson, and to the surprise of many of his erstwhile Marxist supporters, he said the rule of law is a cultural achievement of universal significance. And I started to think, what could he mean by that? And there are various things he could do. But he kept saying a word, and I've been reading him since the book was published in 1975. He kept saying the notion of the subjection of power to constraints, etc. That term, the notion, grabs it. In some societies, like the Bulgaria I mentioned, the notion is either unimaginable by the people who have power, it's just not on. That's not how we do things here. And that's a big deal. It doesn't mean you can't change things, because in many societies things have been changed. Taiwan is a democracy that has a good deal of constraint on power. It wasn't always. South Korea as well. But that's important. And so, to sum it up, it's not just a legal virtue. To the extent that for a long time, because I've been writing so much, it's like a broken record, year after year after year about the rule of law, I got called the rule of law guy, and I got called in as the rule of law guy. Somebody's got a collection on democracy, will you do democracy and the rule of law? Illiberalism, illiberalism and the rule of law. State legitimacy, etc. And there's a whole list of these. I should not confess to strangers because it's embarrassing. But so I was the rule of law guy and I accepted it. In fact, I think I formulated it, but it got taken up. And now I should come out. I'm not now a rule of law guy. I'm a tempering power guy. Why should that make a difference? If you're a rule of law guy and you think, well, the rule of law is all about tempering power, you're still constrained within the kind of cliches and boxes and conventional lists that are taken to be rule of law. But if you say, look, what I'm after is tempering power, do you say prayer will do it? Okay, if prayer will do it, I'll pray more. Well, the evidence isn't in for me, so I'll look somewhere else. It's open, much more open, what will do it, but it's not open that tempering power is an enormously important thing to do. And now to conclude, really to conclude. When I started thinking about the rule of law, Martin mentioned that I came genealogically from tragedy. It's true, but it wasn't my tragedy. I was born on Bondi Beach. But my obsessions were the obsessions of earlier generations who'd come from worse places. And in the 80s, I came to think the rule of law is important. I already started writing, and I just picked up my idea of what it was off the shelf. This is what they said, this is what I said, and I said it's good. And then after the first 10 or 15 years after communism, where I was very excited, I kept thinking, it's not working. And I started to think, well, maybe we should think a bit more differently about it. But then it was a matter of debate with friends. We all had in mind the same goals, and I thought that this was a better way of looking at it. Now the situation in the world has changed. Now the rule of law monopoly moment rhetorically is over. And what one deals with is enemies who quite self-consciously, deliberately, patently are not interested in limitation or in, the tempering of their power. They're not interested in rendering it less arbitrary, except for the extent that it's useful to them. And so this is a debate not with friends necessarily, but with enemies, and all the more important for that it be conducted well. Thanks very much.
I think you'll all agree that was a masterful, reflection on the wider aspects of the rule of law from the tempering power guy. In response, it's my pleasure now to call to the podium Michael Sexton, SC, a graduate of law schools from the universities of Melbourne and Virginia. He spent some time as an academic lawyer before taking up practice in New South Wales Bar. Since 1998, he's been solicitor for New South Wales, and he's been the co-author of one of the first Australian texts on defamation law and several texts on Australian politics and history. He's generously served in public administration as chairman of the New South Wales Rail Authority, as a board member of New South Public Transport Authority and the New South Wales Library. Ladies and gentlemen, it's my pleasure to welcome to the podium Michael Sexton.
Thanks, Martin. I wanted to say something tonight about one aspect of the rule of law, or more accurately, perhaps what I would say is the erosion of the rule of law. And in jurisdictions, perhaps, where it's one might have thought that it had its strongest history, that is in Britain and in the United States and in this country. And when I say the erosion, the trend I'm talking about is what I would call, and others have called, the judicialisation of politics, and by which I mean the transfer of functions traditionally carried out by the legislature in the form of elected parliamentarians, or the executive in the form of ministers responsible to the parliament, to unelected judges in the courts. Now, it's true, of course, that in the case of countries with a written constitution, like the US, Australia and Canada, there will inevitably be constitutional questions that are decided by the courts. But in considering the validity of legislation or executive action, that is, whether they conform to the requirements of the Constitution, there's a question as to the degree of deference accorded by the courts to lawmakers. One reason for the importance of this question is that a political issue does not become a legal issue because it's given to a court to decide. It remains a political issue, but it's one that's now decided in a different way. This last point is reflected in the role of the US Supreme Court. Because of the Bill of Rights, the court has always made decisions on political questions, but in recent times, this reality has become much clearer to both sides of politics and even to some sections of the general community. This realisation has led to protracted struggles between the two sides of politics over the selection of judges for the court. The Senate confirmation hearings for Justice Kavanaugh in 2018 were reduced to days of testimony about student parties 40 years earlier. The court's role in the political process was underlined in June 2022 when it reversed the decision of Roe and Wade, which had stood for almost 50 years, and ruled that the Constitution does not confer a right to abortion, and that this issue was one for the various state legislatures, thereby creating a contentious political question in potentially every one of the 50 states of the Union. The Australian Constitution does not contain a Bill of Rights, and there's no statutory charter of rights so far at the federal level. There are statutory charters in Victoria, Queensland and the ACT, about which I'll say something shortly. But the High Court can, and does regularly, strike down legislation of the federal and state parliaments on the basis that it is contrary to the Constitution. I wanted to give one recent example where it seems to me that the court has exceeded its proper role, and that's in the area of the funding of election campaigns. The court held in a 1992 decision that there's an implied freedom of political communication in the Constitution, and has used this doctrine in recent years to strike down New South Wales laws limiting donations to political parties and expenditures by third parties in election campaigns. This might be thought to be a subject on which the views of elected parliamentarians would carry some weight. But in this area, the court has employed what it calls a test of structured proportionality in relation to the legislation in question. I won't try and decode this test for the audience because I think that's probably an ambitious exercise. But the test proceeds in several steps, and the last is to ask whether the law in question is adequate in its balance, that is, whether the burden it imposes on political communication is justified by its purpose and methods. The scope for subjective judgment here is obvious, and the comment of Professor Thomas Poole of LSE Law School is apposite when he said, "Proportionality is plastic, and it can in principle be applied almost infinitely forcefully or infinitely cautiously, producing an area of discretionary judgment that can be massively broad or incredibly narrow, or anything in between." The court's scrutiny of legislation, the High Court's scrutiny, would of course be greatly increased by the enactment of a federal Bill of Rights. This was recommended by the majority in the report of a federal parliamentary committee, the Joint Committee on Human Rights, in May of this year. As is usual in these kinds of inquiries, almost all the submissions came from legal academics and legal professional bodies and argued in favour of a Bill of Rights. These groups believe that judges are better qualified to decide many political, social and economic questions than parliamentarians, and they're conscious of the fact that it's often easier to achieve a particular outcome by way of a judicial decision than by more complicated and time-consuming parliamentary process. The report gives no weight to the fact that a Bill of Rights will result in a significant transfer of power from the Parliament and the Executive to the judiciary. In this case, the transfer of power would be very considerable, as in addition to traditional subjects such as freedom of speech and freedom of assembly, the committee recommended the inclusion in any Bill of Rights of such social and economic concepts as housing, education and health services. These have, of course, traditionally been matters of budgetary allocation by governments in accordance with policies that have been taken to the electorate. The notion that these questions should be the subject of litigation in the courts is, in my view, rather astonishing, although you may have read, I think 3 weeks ago in the Saturday edition of the Sydney Morning Herald, a piece by Kevin Bell, who's a former Justice of the Victorian Supreme Court, who argued that the solution to the housing crisis was to have a Bill of Rights and to have housing as a right under the Bill of Rights. Well, good luck. As I mentioned earlier, Victoria, Queensland and the ACT have statutory charters of rights, and they are the subject of constant litigation as legislation is challenged on the basis that it's inconsistent with the Charter. It might be noted that Queensland and the ACT provide for a right to education, and Queensland, additionally, a right to health services. Even in the UK, which does not have a written constitution, questions can arise as to the proper demarcation between the Parliament and the Executive on one side and the judiciary on the other. This occurred in August 2019 when the British Prime Minister, Boris Johnson, advised the Sovereign to prorogue the Parliament for a month so that the legislation might not cut across the government's negotiations with the European Union on Brexit. The advice was challenged as unlawful in the English and Scottish courts. At first instance, in both jurisdictions, the challenge failed on the basis that the issue was not justiciable. That is, a finding in effect that this was a political question with which the courts would not interfere. The question was finally considered by the UK Supreme Court, which held that the issue was justiciable and that the advice was unlawful. The court's key finding was as follows. For the purpose of the present case, therefore, the relevant limit upon the power to prorogue can be expressed in this way, that a decision to prorogue Parliament, or to advise the monarch to prorogue the Parliament, will be unlawful if the prorogation has the effect of frustrating or preventing, without reasonable justification, the ability of the Parliament to carry out its constitutional functions as a legislature and as the body responsible for the supervision of the Executive. In such a situation, the court will intervene. The effect is sufficiently serious to justify such an exceptional course. So one can think there of the terms reasonable, serious, exceptional, and see the degree of subjectivity that's available for a court employing those terms. And they underline, in a sense, the views of the court below, the correctness, I would say, of the courts below. that there was an absence of judicial or legal standards by which to assess the legality of the executive's action in this case. The court added that the Prime Minister's wish to end one session of Parliament and begin another would normally be enough in itself to justify the short period of prorogation that had been normal in modern practice. Does this mean, therefore, that the proposed prorogation, if it had been for 3 weeks rather than 5 weeks, that would not have been a problem? What about 2 weeks or 4 weeks? As the Divisional Court, that's the lower court, noted, the Parliament was prorogued for 3 months in 1930, for almost the same period in 1914, 2.5 months in 1901, without anyone taking any action. The court observed finally, nowhere is there a hint that the Prime Minister, in giving advice to Her Majesty, is more than simply the leader of the government seeking to promote its own policies. Well, one might wonder what else the Prime Minister would be doing. One might imagine this is the basis of all decisions of the executive government, tends to underline the political character of the issue before the court. It might be noted that the decisions at first instance by the lower courts in many ways reflected the consideration of the issue of justiciability over the years by the US Supreme Court. In Baker and Carr, decision in 1961 about electoral distributions, the US Supreme Court observed that the lack of satisfactory criteria for judicial determination was an important consideration, and it added that the non-justiciability of a political question is primarily a function of the separation of powers. Accordingly, it referred to the problem in relation to a political question of there being a lack of a judicially discoverable and manageable standard for resolving it. I might say that in this case the US Supreme Court nevertheless held that the issue was justiciable, but Justice Frankfurter in dissent said on this question, the crux of the matter is that courts are not fit instruments of decision where there is essentially at stake the composition of those large contests of policy traditionally fought out in non-judicial forums by which governments and the actions of governments are made and unmade. So on the question of judicialisation of politics, John Gray, writing, perhaps surprisingly, a few weeks ago in the New Statesman, a journal that would probably favour the judicialisation of politics in general, but Gray spoke of the progressive project that has captured the ruling political class in Britain and much of the West, the goal of which is to replace politics by judicial process and rational administration. He went on to say that judges will be given increased power to make essentially political decisions about the allocation of resources. We're seeing a lot of litigation, of course, in Australia now about climate change, mining projects and so on, where judges are making decisions about the allocation of resources. And Gray concluded, rather pessimistically, the power of government is being ceded to non-elected authorities, apparently permanently. If it could be fully realised, this post-democratic version would mark the end of the sovereignty of Parliament and a fundamental alteration in governments. Post-democratic, I think, are the particularly important words in that quote. So these warnings, or more accurately predictions, are especially opposite to proposals for a Bill of Rights at the federal level in Australia and in those states and territories that don't currently have such a statutory charter. But they're also relevant to the more general principles of judicial review and constitutional interpretation. I'll stop at that point.
Thank you very, very much. We're going to have about 25 minutes of Q&A. I'm going to kick off with a few questions, and then we have a number of roving mics. Martin, can I start with you? I was in Europe in 1989. Everybody was terribly optimistic, and the rule of law was a gravy train for legal academics to spend large amounts of time in Central and Eastern Europe explaining how the rule of law. It was largely a technical, thin conception of the rule of law, architectonic in nature in terms of institutions, etc. You're now suggesting that 30 years later, that was a misplaced endeavor and that we really should have been sending the sociologists and not the lawyers.
I don't think anyone's very smart. I think, but yes, if you want a slice of sociology, a great sociologist and somebody who's mattered to me, called Philip Selznick, he became a sociologist of law, but when he was young, he was an organizational sociologist. And his first book was about an American agency which was completely well meant, the Tennessee Valley Authority, where it was unprecedented. It was a federal agency. It was going to work in various states. And when it was accused, when it was alleged that this would mean that all the power would just gravitate to the center, on the iron law of oligarchy, the center people said, oh, no, because we're going to bring the local people in. TVA, Tennessee Valley, and the grassroots. That was the name of his book. What he found was that to buy off local notables, they systematically favoured they lost control of the store. So blacks were, of course, excluded. Poor whites were excluded. Various agendas were excluded. So that was a failure. Then he did a book called The Organisational Weapon. How is it the communist parties, what sort of organisational strategy do they develop to do something very difficult, to turn recruits into deployable agents? The post office can't do it. Universities are having more and more difficulty doing it. You get these people off the street and they become yours. So then he wrote a book called Leadership and Administration. And he said, and he was trying to, how do you lead successfully? And he said a leader will never understand, if you think of organisations in strict formal terms, you'll never understand the difference which is crucial between organisations and institutions. Institutions are infused with value beyond the need of the technical task at hand. And the problem, what a leader has to do is understand that there are many already institutionalised outfits out there, and if she or he wants to change anything, they have to understand that, and they have to work out ways of infusing with value. Now, our guys, and I was one of them, thought, I was not a player, but I was interested, thought this was part of the end of history moment. We've won. It's absolutely clear. This is the way to go. There is no alternative. And we roll it out. We roll out all this this organisational stuff. We roll out constitutions, we roll out constitutional courts, etc., etc. We get people to advise them how it's done in Atlanta, Georgia. We send them to Tbilisi, Georgia. Well, it's just the same. And we've reaped the whirlwind at the hands of people who I think subliminally understand this. Orban understands it. Kaczynski. The populists, modern populists, understand this is not an organisational game. We're not going to say that there is a difficulty, a legal difficulty in Clause 7 of the Constitution or in the way that the Constitutional Court has interpreted this. We're going to say this is contradictory to our values, ours as Hungarians, ours as Poles, that these people with their flabby, weak, postmodern, etc. value are undermining our true noble heritage. They're on the right train in the wrong purpose. And we never thought, so sociologists couldn't tell. What do sociologists know? But the issue is sociological, cultural change as much, arguably more, than technical organisational change.
What are the implications for that, though, in terms of in the face of emerging illiberal democracies that are putting in place, if you like, using the mechanisms and the institutions? What are the implications long term? you've said context matters. You've indicated, I think, that it's the issues that are perennial, not the problems. So what are the implications for the emergence of these illiberal democracies, in particularly as we see it in the moment in Europe?
Am I going to get all the easy questions? So basically, I don't know. I think I am largely pessimistic. I think that one of the difficulties is that when illiberal regimes come in, they want to stay. Orbán has said in Hungary he wants the regime to last longer than he did. The source of optimism is that that was also the plan in Poland, and they failed. And this is a fascinating moment in Poland, in Brazil as well, and not in India, not in Hungary. That what do you do afterwards when these people have done what you never thought to do before, tried to cement their guys and their institutions? Just one example, and I'll stop. In Poland, the Minister for Justice was quickly also became the procurator in charge of the whole legal system. That was called the General Procuracy. He had a whiff, probably in September last year, that they might lose. And then this office would go to his successor. So he called out of retirement a mate who had been a witness at his wedding a long time ago, made him a subordinate position, which is called the National Prosecutor, had no powers. He made him National Prosecutor and transferred all his big powers to this underling. And when the new guys came in, they found a technical trick to undo it, but they weren't supposed to find that trick. So one of the problems is illiberal forces are in many places in Europe, but they're not in power in many of those places. And so they don't have this apparatus available to them, and their success or lack of success will depend on a whole range of extraneous geopolitical and other factors. If they get into power, they will do their best to cement it, and that is a worry.
One more question before I go to Michael Sexton. The building next door, one of your early, if I have this right, one of your early PhD students, David Neal, and Cable?
Friend.
A friend. Cable and at the very, very, very beginnings of this city, this colony, when the culture couldn't have been described as sort of reflecting the best of what Dicey might have described as the rule of law in terms of as a penal colony. What were the conditions that were present then, and maybe provide some of the context as to how the common law and in some respects the rule of law in a very thick sociological way was transported here along with many other people?
David Neal was a colleague, wasn't he, of yours, or had you already left UNSW? He's a friend of mine. He was an academic at UNSW. He did a doctorate in a new program in Berkeley, which tried to do what I'm trying to advocate in the more jurisprudence and social policy, but the three together, not just jurisprudence, sociology, or policy. And his book, the book of his thesis, was called The Rule of Law in a Penal Colony. And its question that he set himself was, how did a colony which was set up simply as a penal colony after you couldn't transfer convicts to America, become in the space for the convicts, become in the space of 40 years, by 1840 was roughly his time, a free society for white settlers, including convicts and emancipists. That's a real puzzle. He was influenced by the guy that I mentioned, E.P. Thompson, who had argued that 18th century England, law had a real rhetorical and real significance, greater than religion, and certainly greater than it had in many other societies. David argued that what accounted for the extraordinary use, as it was, because there were no political channels, of legal channels and legal arguments by convicts to get trial by jury, to have various rights recognised, to have their position equalised, if you like, to the free settlers who were trying to battle against them in all the way. This was in significant part a result of the cultural baggage that the convicts, as well as their guardians, shared. and which framed the arguments and the imaginations of many of the people involved. I think that's a hugely important argument. He begins, and you mentioned it, he was hoping that somebody would pick it up for a film, but it hasn't happened. So, Henry Cable was convicted and sentenced to death, was in Norwich prison, and met there, and his sentence was commuted, his father was hanged, for some what we would consider petty crime. He met there Mary, also convicted of a pettier crime. They fell in love, they had a child, and they were nominated as among the first in the First Fleet, but the person nominating said, but not your kid, it's too complicated. The turnkey was full of compassion. He went with the child from the prison to London to beseech, this sounds like a film, to beseech with Lord Sidney to be allowed, that they be allowed to take the child. They were allowed, but this got into newspapers. There was some, a lot of sympathy, and some aristocrat gave £20 from which they bought various provisions. When they came, they discovered that the £20, that the provisions were not there in the boat. So the first civil case in New South Wales was Cable against the captain of the boat. And when I reviewed the book a million years ago, it came out in 1990-something, and started to speculate, because that's where my head is a lot of the time, what if the Russians had settled in Australia? I mean, where would the courts have been? The whole frame would have been different. So that's the positive story. This negative story is Aborigines didn't get the benefit of any of this, even though the technical laws were the same for the first. They weren't special laws. But there was a cultural gap, a cultural non-recognition. Many other things could be said. And I think it is testimony to the significance of these cultural features, which are not unchangeable. You can lose them, and or you can gain them, and it's good to gain them.
Michael Sexton, your analysis of increasing judicial power impinging on parliamentary sovereignty, your sense of the direction of that, is it inexorable, inevitable, or do you think that wider sociological, cultural, political changes will see that a pushback against that?
I say regretfully that I think it is inevitable, and I think that's reflected in not just in bills of rights at various levels in Australia and in other countries, and in Britain, of course, as well, but also the judicial review by the courts of administrative action, which is really in, say, last 40 or 50 years become such a... Now, it's true that the parliaments, of course, agree to that kind of judicial review, and I'm not suggesting that system, that there should be no such system of judicial review, but the role of the courts has become so large, I think, in our society and in Britain and in the US over the last 25, 30 years. And as I say, I just gave the example earlier of litigation about climate change, about the approvals for mining projects, very large economic questions for this country, which are to some extent in the courts.
Parliaments around the world are full of lawyers, though. The predominance of lawyers in our national parliament, in Congress in the US, is that part of the professional, what Martin called the professional deformation, is part of the challenge that, within these mechanisms, within these institutions, potentially a future president who served as a law officer, etc. Is there a sense in which, to Martin's point, those that seek to have power recognize that one way of securing that, flattening that power and then encompassing it, is through this mechanism?
It's slightly deceptive, I think, the number of lawyers in parliaments, because the way in which people are now mostly, not entirely, going into public life, into elected public life, going in young, very young, before they've had any other career, and getting out quite early to do something else. But so that the fact is that there are very few lawyers amongst the legislators who've actually had any real knowledge of the practice or the theory of law, if it comes to that. I must say, when I gave the example of the Parliamentary Human Rights Committee and its recommendations, at first blush it would seem something of a puzzle that these legislators would propose to give up some of their powers and to transfer them to the judges and the courts. But I think that probably indicates that they don't really have a sense of their role, that in fact that they don't see themselves as implementing policies and making significant changes to the laws. I think that they're happy, in a sense, to push those tasks onto somebody else.
Martin suggested that the rule of law has to have a parochial element to it, or tempered power. Perhaps politics has become parochial. We may go to the floor at this stage. We've got a number of questions. We might start, we've got roving mics. We might start in the front. If you could just give your name and your affiliation.
Yeah, Ian Benson, Professor of Law at Notre Dame. I was just with Martin in Korea at a conference a month and a half or so ago, and I heard the same paper, slightly different version. But it's given me time to reflect on the substance of his paper. And I was interested in, is it Mr. Sexton's response? They were ships passing in the night, I think. But let me suggest a meeting. And the meeting is this. Martin would have us invoke one of the cardinal virtues, temperance. Why that one, I'm not sure, when justice is another of the cardinal virtues, and one would have thought closer situated to law itself. And the problem with that approach is really basically this, and particularly in Australia, it's a serious problem. This is a culture dominated bow to stern by legal positivism. Virtues don't come from legal positivism, they come from the natural law tradition. And like it or not, virtues depend on a whole series of dispositions, another term Martin used, which go to the heart of the problem of legal positivism. It does not give us a richly moral culture at all.
And your question is?
Okay, this is where it meets Mr. Sexton's point. The issue is not whether it's judiciary or politics. The issue is the kind of judiciary and the kind of politician. As you can tell from my accent, perhaps, I'm from Canada, where we've had a repatriated constitution since 1982, and we've seen systematically the so-called dialogue between courts and politics, subverted time and time again as it suits the culture of the time. Sometimes they will want to defer to the courts because they don't want to do it. Sometimes the judges will try and get around something because they don't want to do it. What we have is a massive failure of moral culture. That's where your two papers meet.
Okay, if you're not going to ask a question, I'm going to cut you off.
That's the question is this. Is it not the case that there's an alternative to an entrenched Bill of Rights that allows a restriction on the remedial power of judges?
Michael Sexton, think about that.
An alternative to an entrenched Bill of Rights? You're talking about a charter.
The way you debate it here is as if it's all judges or it's legislatures. But you could have an act that sets out your all the fundamental rights, but limits the power of the judiciary to declaratory power only. I never hear that debated in Australia.
Well, to some extent, you've got a charter. It's not entrenched in the ACT, in Queensland, and in Victoria. Yeah. And yes, you're quite right to say that there's notions of declarations rather than striking down legislation and so on. But inevitably it transfers these. I mean, my objection is it transfers political questions to the courts.
It doesn't have to.
Well, I think it's inevitable because they are political questions. Even in traditional areas like freedom of speech. I mean, you decide how much freedom of speech there will be.
I'm going to take another question. Just behind. And if you could, a question, please.
Yes, my question, Karen Kerman, very interesting, thank you very much. My question was about the role of culture and trying to impose a culture of both the rule of law / democracy on other civilizations who don't have that tradition. And you've got lots of examples. Iraq is a great one, but you can go back to the Weimar Republic in Germany, which was a dismal failure. But Germany today has a culture that is completely different. It is a democracy. It does have rule of law, with all the flaws that we have. And I just wondered, Martin, if you could just comment on whether that is an example where the culture and traditions have been able to successfully move, or whether you think that's an anomaly and generally you can't change the culture and traditions to that extent.
Quickly, in answer to Ian, do I think legal systems should do justice? Yes. Do I think the rule of law should be defined in those terms? No, because I think it has a specific province. Everybody agrees that we want justice out of law. There's something about arbitrary power which is distinct from other virtues we want. It's not necessarily the same range. It's a foundational virtue. You don't want it for yourself. You want it because you don't want people with it to screw other things up, among the reasons because you want certain virtues, among them justice, equality, liberty, whatever is your fancy. To your question, I don't think, and I think we have plenty of evidence that that cultures are unchangeable. Germans weren't Nazis before they became Nazis, and they're not Nazis now, or at least most of them aren't. Gay pride was not a concept in my youth, nor black pride. They are now. That's a change, deep cultural change. There was no democracy or rule of law in Korea, even South Korea, even a few decades ago, Taiwan, there is. These things can be changed. One of the, I think, moral paradoxes is imposing. If you were a real cynic, you might say you can only do it effectively if you can impose it effectively, which happened in Japan and Germany. If we try to impose, which is anyway in most circumstances the wrong thing to do, we can't do it because we don't have the troops. One of the fundamental reasons for change in Germany and Japan was American troops on the ground, or Western troops on the ground, and that's not a palatable option for the rest of the world, or much of it.
Peter Anstey, question here. Lottie, thank you.
Yeah, so Peter Anstey, Philosophy, University of Sydney. A question for both of you. Is the way to stop the erosion of the rule of law and to temper arbitrary power to re-emphasise and get the equilibrium right in the separation of powers, the legislative, the executive and the judiciary?
Who wants to take that? Michael?
Well, I mean, in one sense, the answer is yes. But the problem then becomes how you devise that separation of powers. I think my point was that I thought, to some extent, in Australia at the moment, and perhaps also true in Britain and in the US, that the judiciary had taken a role that was never perhaps originally intended by those who drafted the foundation documents. So the answer is clearly yes. But the question is, how do you do it? And it seems to me that the trend is rather moving in the opposite direction at the moment.
Martin?
Well, I think there's more than one trend. So what Michael has been talking about, England, America and Australia, is the judicialisation of politics. In the populist countries I look at, and not only the populist countries, in dictatorships of all sorts, the real trend is the politicisation of the judiciary. It goes without saying of the Soviet Union, Nazi Germany, and China, and so on, North Korea. The interesting thing about populists is that it goes without saying, that is, you pretend that you're using these institutions for the reasons they were founded very recently, but in fact, no one who is running the show thinks of that. The only thing is, get your guys in there. and that's what they do. So I think the equilibrium is being buffeted from many directions in the world. I'm more worried about... Yeah. Yes, I should have said yes to start with.
Question in the middle here, Lottie, and then I'll go to question at the second row from the back, and then we come to the front. I am going to maybe keep questions going for about another 5 minutes, if people agree. If you could introduce yourself and question, please.
Jared Dominish, first year UOW Law and West Civ student, Ramsay Scholar. Basically, frankly, my question is, what is the solution? How can we temper power? Is the rule of law meant to be the universal, is the rule of law meant to be a universal objective implementation? If so, who determines what the rule of law is? Is it common law countries that do this? Then, if needing to impose the rule of law because it matters, how is it then implemented? Does it rise up through education of the people to some legal revolution, or does it come from the top down? How does one regulate that, including outside of the state? Finally, is there an opportunity for arbitrary power to coexist with the rule of law?
Martin, first part of the question,
easy.
maybe.
No, fine. I think tempering power was a cultural achievement of universal significance. But that's important. That's the phrase of Thompson. I think tempering power is of universal significance. It would surprise me to learn that the rule of law is of the same significance. There are many ways of doing things, many forms of society. In large industrial societies with big states, the law is going to be a major player, but all those other things are important, and they're not going to go away. There is no one way. It is a cultural achievement, which doesn't mean it's got to be the way we've always done it. That's never been the case. India, the courts until recently, were doing a good job, partly because they were different and they were not in the grip of all sorts of local players, or at least that's an argument that can be made. It's a very, very complicated piece of social engineering. We don't even know well how to stop people smoking. Why should we know that how to do that? I'm trying to, partly because I'm an academic, so I don't have to make any practical decisions, but also because it really is complicated. And the quick fix, one identikit way of saying this is the solution, because it's worked somewhere, even where it's worked, the sources of it are unlikely to be the things you pick up and transport, because they had cultural understandings within which they were enmeshed. And when you take them to the other places, cultural understandings are going to be different, and so the interpretations.
Michael.
So it's hugely complicated and variable.
And then I'm going to go to the questioner down here. Go.
I quite agree that the avoidance of arbitrary power is in a sense at the heart of the debate about the rule of law, but I'm about to say something very unfashionable, which is that the rule of law really was a British product and translated to the countries that it settled. And as I say, this is probably not a popular thing to say, but and I doubt that Martin would agree, but there are real difficulties, I think, historically shown, of trying to translate the rule of law as it emerged from centuries in Britain to countries which were not settled by the British.
Question, person with hand up, and then we'll go to the person in front with glasses. So, Jack, if you can do, let's go in that order, yes, and then we'll go to the person behind.
Would a return to the jury system, where the jury has more power than the judge, stem the tide of the erosion of rule of law?
Yeah, I think
If you
that's
can hand the mic
for
back
me.
to the person behind you.
Judges are, of course, juries are, of course, largely directed by judges as to the legal position. It's quite true that a jury can, in a sense, take an independent view. Juries are now largely confined to the criminal law, and there are a whole lot of problems in that area because we've got trials that are going for 3 months, 6 months, 9 months. and it seems to me impossible that you can take people out of their ordinary lives for that period. I think when 30 and 40 and 50 years ago, when you had much shorter trials and less complicated legal exercises, I think the jury system worked pretty well. I'm not so sure now. I think, particularly in the area of criminal law, we probably need to have more judge-alone trials. And I accept the premise of the question that in an ideal world, I think juries would have a really important role to play. I think to some extent, however, they've been overtaken by the events of the last few decades.
Person at the back with the mic.
Justin McGovern. I'm a lawyer, soon to be BCL candidate and Ramsay scholar. From listening to the two speeches just now, it seems to me there is a tension between the democratic will expressed by the people of whichever country seeks to exercise that right, and the tempering of the exercise of the power those people yield up to their representatives by judicial officers. And I'm reminded of a study late last year around the world that indicated, tragically in my view, that up towards 33% of people under 35 would prefer literally anything else to democracy, and they have begun to lose faith in the effectiveness of their power at the ballot box. You spoke about populism and Orban receiving supermajorities north of 60%, I suppose. There's probably an argument to say that is a democratic expression of the will of the Hungarian people. And so the fundamental question I would ask both of you is populism incompatible with the rule of law or the tempering of power, as you put it, Martin?
Orban got his first two-thirds majority with 53% of the votes. And it's a complicated electoral system which favours large parties, and it's favoured them in each of the elections, but clearly he's the winner. But your question's a large one. I mean, we don't have time to explore the word, which is like all these words, rule of law, all the others, abused, and not even abused, but if democracy obviously is about who governs in some complicated way, and so you can say, and populists certainly do say, that they are democratic because they have free elections, very rarely fair elections in the countries that I look at. But along with them, there is a whole range of other features of these particular regimes and their leaders. Because one is, it's not like a democracy where we we understand there are differences, and this is a mechanism for somehow allowing them to live together in civility. The modern populace differences are the differences of friend and enemy. And so you don't, in fact, claim to be ruling on behalf of the whole. You rule on behalf of your people. The others are not true Poles, Poles of a worse sort, as Kaczynski puts it, or not true Hungarian, as Orban puts it, or whatever Trump has popped up with this day or that day. But it's always going to be one which sets against, of course, elites, foreigners, all sorts of other people, will be set against the true, authentic bearers of the nation. But democracy is a virtue and a value huge, but it's not the only game in town. There are other criteria, and one is that wild power stinks. It's a technical term, but wild power, arbitrary power stinks. We have a lot of examples of it. It wasn't just Democrats who were opposed to it. When, for the whole of history, between the moment, the sort of flash moment of the Greeks, and about a minute ago, there weren't any democracies, but there were real, serious thoughts about why untempered power, it's often called that, tyranny, arbitrary power, was horrendous, as it so often in its consequences turned out to be.
Michael, last word, and then we'll adjourn for the evening.
Populism, in many ways, has now simply become a term for something that you don't like. The other side, to put it, I suppose, to put it that way. Democracy is, I think, as Martin says, I mean, I think extremely important, and I suppose my remarks tonight were really to suggest that democracy was to some extent being undermined by this process of judicialisation. But it's also important to remember that democracy in any country, and including in Australia, is far from perfect, and that the systems of democracy that we have could naturally be vastly improved. They probably won't be, and we'll be still talking about these kinds of issues well into the future. But it's an ideal, and I suppose as long as we don't give up on the ideal, at least that's something that to look forward to, and the issue is still discussed in Australia and in other Western countries, and its imperfections are being acknowledged.
Thank you very, very much. Ladies and gentlemen, could we please have a round of applause for the speakers? Could I conclude? We're going to adjourn for refreshment. Could I remind people, and a note for your diaries, the last week of October, Robert Kaplan, renowned international journalist and author of numerous books on geopolitical issues, and more recently, A Life in Tragedy, will be in Sydney for a week with the Ramsay Centre for Western Civilization. We will be sending out a save the date. For those of you who are interested in well-tempered power, a cultural achievement of universal significance, Martin published on this in the Hague Journal of the Rule of Law, and I think if you're nice to him, he might be able to share a copy of his thoughts. For those of you who are interested, if you contact the Ramsay Centre, we'll pass on the correspondence. Thank you very, very much again to both our speakers. Thank you to the venue. Thank you to all of you who have attended. And again, please show our appreciation to the speakers and join us.